panel discussion. My name is Alyssa Haydari, and I am the Deputy Director of the IIP. The IIP provides a collaborative national platform that brings together prosecutors, policy experts, and the communities they serve to promote data-driven strategies, cutting-edge scholarship, and innovative thinking. This is the second of a three-part webinar series about wrongful convictions. Last month, we examined the exoneration of Mark Denny, who was wrongfully convicted of a rape and robbery in Brooklyn that he did not commit. You can watch that panel discussion on our website if you missed it. Today, we at the IEP are honored to have such an impressive and well-respected group of leaders tell us about their experience as attorneys in the exoneration field. Before I introduce our guests, I'd like to take this time to read the IIP's land acknowledgement statement. We want to acknowledge that the IIP and John Jay College are based in New York City, which is Lenape-Hoking for the Lenape homeland. We honor all of the indigenous nations and their land with great gratitude and acknowledge the genocide and continuous displacement of indigenous peoples. We also acknowledge the enslaved Africans whose labor built Manhattan during the colonial era and beyond. We acknowledge the harm inflicted upon the indigenous communities and people of color across the country, which inspires our ongoing work. Now let's meet our panelists. For time's sake, I'm going to keep the bios very short, but we will put a link to each of the panelists' full bios in the chat. I encourage you to check them out to learn more about them and their work. First, we have Shelly Thibodeaux, who joined Florida's 4th Judicial Circuit State Attorney's Office in 2018 to become the director of the newly created Conviction Integrity Review Unit. After graduating law school, Shelly worked in private practice for several years. Her practice included both trial court litigation and appellate members. Shelly is a member of the Florida Bar, the Jacksonville Bar Association, and the United States District Court for the Middle District of Florida. She is also a certified family law mediator. Risa Gerson is the chief of the Conviction Integrity Unit at the Bronx County District Attorney's Office. Ms. Gerson joined the Bronx DA's office in September 2016. Previously, she worked as a defense attorney in multiple organizations and in different capacities, including as Director of Quality Enhancement for Appellate and Post-Conviction Representation at the New York State Office of Indigent Legal Services. From 1996 to 2012, she was a supervising attorney at the Office of the Appellate Defender, including as Director of the Reinvestigation Project from 2009 to 2012. Cynthia Garza is the Special Fields Bureau Chief of the Dallas County DA's Office and the Chief of the Conviction Integrity Unit. Ms. Garza established her own law firm after graduation and later joined a criminal defense firm where she honed her skills in appellate and post-conviction criminal defense. Ms. Garza joined the Dallas County DA's Office's Appellate Division in 2008 and then joined the Conviction Integrity Unit in January 2010. She served as acting chief of the unit for 10 months before being named the chief of the CIU in July 2017. Ms. Garza is the longest tenured prosecutor in any conviction integrity unit in the nation. Valerie Newman began her career as an attorney with the State Appellate Defender's Office, where she practiced for over 23 years. In November 2017, she was hired as the director of the newly created Conviction Integrity Unit of the Wayne County Prosecutor's Office. In this position, Ms. Newman is working to strengthen the criminal justice system by investigating claims of wrongful convictions. In the 3 years that the unit has been in its existence, it has received over 1,500 requests for investigation. With a small staff of highly experienced attorneys and investigators, the unit has received over 500 cases and granted relief to 26 men, most of whom were serving mandatory life sentences. And last, we have Barry Scheck, a professor at Cardozo School of Law in New York City. Barry and his colleague Peter Neufeld co-founded the Innocence Project, which uses new evidence of innocence, including DNA testing, to exonerate the wrongfully convicted. The Innocence Project works with criminal justice stakeholders to pass state and federal legislation to reform the criminal justice system in the areas of law enforcement accountability, including eyewitness identification procedures, interrogation methods, crime laboratory administration, and forensic science research. In its 28 years of existence, 375 people have been exonerated in the United States through post-conviction DNA testing. Professor Scheck has written extensively in the field of wrongful convictions, exonerations, and conviction integrity units. Thank you everyone for joining today's panel. I want to encourage our audience to use the Q&A function at the bottom of your screen. You can send us questions throughout today's panel, and if time permits, I hope that we can get to some of those questions and have our panelists answer them. So we will start with the prosecutors in the room. Just so our audience has some context for your perspectives, if you can just briefly tell us a little bit about your jurisdictions and the size of your units. Perhaps we can start with Shelly, please.
Good afternoon, everyone. Thank you for inviting me to participate today. So my office is located in Jacksonville, Florida. We're located in Northeast Florida. The state attorney's office for the 4th Judicial Circuit comprises 3 counties, Clay, Nassau, and Duval, the largest of which is Duval, which is where Jacksonville is located. We serve approximately 1.2 million people. My unit was created in January of 2018. At the time, we were the first conviction integrity unit in the state of Florida. There are now 5 throughout the state of Florida. And my unit is comprised of myself. I'm the only attorney in the unit. I have 1 full-time administrative assistant and 1 full-time investigator. And because I'm so small and I knew that I did not have a likelihood that I was going to grow anytime soon, we are now partnered with the law schools at both FIU, Florida International University down in Fort Lauderdale, and the University of Florida. And I have 12 law students from FIU and 12 law students from UF helping me review petitions.
Thank you. Cynthia Garza, if you can go next, please.
Hi, everyone. I am the chief of the Conviction Integrity Unit in Dallas, which serves a population of about 2.6 million people. We have about 275 prosecutors in our office, and our unit is an independent unit comprised of 4 attorneys, 2 investigators, and 2 support staff, 2 legal assistants. And we started off in July of 2007 with only 2 attorneys, 1 paralegal, and 1 investigator. In 2017 is when we grew and we added 2 more prosecutors. And later on in 2019, we got a grant, the post-conviction DNA grant, the Bloodsworth grant, and we were able to staff our unit with an additional attorney, investigator, and support staff. So we have just a ton of requests every year, but we could use more attorneys, but we're good with what we have right now.
Risa Gerson.
Hi, good afternoon, and thank you for having me. I'm from the Bronx County District Attorney's Office. The Bronx is one of 5 boroughs, which is also its own county as part of the city of New York. The Bronx has about a population of about 1.4 million people. The Honorable Darcel Clark, who was elected in January of 2016, started the Conviction Integrity Unit in the Bronx. It started in April of 2016 with 2 attorneys. We were up to 5 assistant district attorneys over the summer, and 3 of them left. So there's now, and then we hired a lateral. So we now have 3 assistant district attorneys, myself and 2 others. And we have an open position if anybody's interested. It's listed on the Bronx District Attorney's website. We also have a paralegal, and we use detective investigators from the Bronx District Attorney's Office on an as-needed basis to help us investigate our cases. Since 2016, we've had approximately 6 exonerations. No, I'm sorry, 8. We just had 2 recently, 8 exonerations.
Thank you. Last but not least, Valerie Newman.
Thank you for having me. I hail from Wayne County, Michigan, which is in Detroit. We have a population in Wayne County of about a little over 1.7 million. But Wayne County has a distinction of handling probably over 40% of all serious felony cases for the entire state of Michigan. So it's a very, very busy court that we have here. I have myself, 2 full-time attorneys, 2 part-time attorneys, full-time admin, and a full-time detective in the unit. And then I also have the same grant that Cynthia has, the DNA grant. And so through that grant, I have a full-time detective and a part-time law student who helped me out.
Thank you. So I think now that we have a pretty good sense of where our panelists are coming from and how many people they have on staff, Barry, I was never going to completely leave you out of this conversation. So the next question we'll give to you. As co-founder of the Innocence Project, you've obviously been involved in exonerations across the country for many years. In your view, how has the field evolved, if at all, since you started this work?
Well, enormously. You know, it's not just DNA testing, it's all kinds of evidence that leads to exonerations. But I think one of the most important developments is the conviction integrity units. And, but I am biased because, you know, the Innocence Project had a lot to do with setting up each of these units. Let's just be honest. In terms of Dallas, I think that that is probably the first conviction integrity unit that we would recognize as similar to the ones we have now. And when Craig Watkins was elected district attorney, I must say that the Innocence Project had a lot of trouble, even with DNA testing, being able to exonerate anybody. When Craig got into office, he hired Mike Ware. Cynthia, I thought she was there from the very beginning in 2008, but you know, soon got involved. And but one of the things that's interesting is that when they started to form the unit, the Dallas City Council said, well, we'll give you some money to set up this unit, but you have to get a matching grant. So it's not much of a secret that the Innocence Project had a connection to the Jet Foundation, which eventually left as a philanthropic entity because of Madoff, but they gave the matching grant. And a lot was done to set up the Conviction Integrity Unit in Dallas with people from the innocence organizations and the defense bar. Mike Ware, the first head of it, was from the Innocence Project of Texas. And the reason I say that is that in each of these offices, and I think it's a good example with you know, Risa and Valerie certainly, and Shelly, we talked a little. I know we had a case with Melissa Nelson. You were elected just before. When she was in the office, there was a kind of conviction integrity reinvestigation. But I think it's extremely important in most instances to have somebody in a position of running a conviction integrity unit who's been a defense lawyer, certainly has been through that process. That helps enormously. So when you look at the Registry of Exonerations, and I'll end with this, we've been keeping track of exonerations in the United States. And maybe it's not the best term, but lately we at the registry have been referring to it as professional exonerators, right? And when you look at all the people exonerated in the United States, DNA, non-DNA, it's rising considerably. You'll see that so many of these cases are either from innocence organizations or innocence organizations and conviction integrity units. So that has been a major, major development just in terms of getting innocent people out of prison and identifying the people who really committed the crimes.
That is something that we at the IAP have also noticed is the rise in conviction integrity units. And one of the reasons we wanted to have this panel is because we often get inquiries from people like yourself who are trying to set up a conviction integrity unit or have one, but are having problems. And so one thing I wanted to just open up to everybody on the panel is if we have prosecutors on this call now who are wondering, what are some things that I should consider before I set up a CIU? What are the things that people should consider? Maybe some pitfalls or anecdotes you can share in terms of problems to avoid. Anybody who would be able to answer that question, because that's something that we get asked all the time.
If I may, when we started our CIU in Dallas, we didn't have a blueprint. We didn't know basically what we were doing in terms of, you know, how to keep track of our cases, how to do, I mean, we just did what we thought was the right thing to do. Through the years, we have, you know, changed the process and implemented different procedures and processes that weren't around back when we started the unit. In 2007, you know, we didn't know basically what a lot of people, and we didn't have the resources that a lot of people would have now. I mean, there's, you know, what, 4 of us on this call that could, you know, give some tips and pointers. Back then, we didn't have that. I would, you know, just kind of put out there for anyone who's trying to establish a unit. First and foremost, you have to have independence. Your unit has to be independent of the post-conviction unit in your department, in your office, has to be. Second, I would suggest that the CIU chief report directly to your elected. I think that has been, those 2 things have been very, very important in our office and for the success of our unit, because you minimize the kind of the disruptions in the case investigations and things like that when you have internal fighting. So, you know, eliminate those barriers for your CIU if you truly want a successful one. Those are some tips and pointers that I would say you have to start off with and seriously consider when you're establishing your unit. Also, there's just a bunch of different networks that have been established around the country to help people establish a CIU, to help prosecutors establish a CIU within their office. Tap into those resources, please. You need to. And your network will grow. And there are so many people just around the nation who are passionate about this work and will talk to you and give you tips and pointers that worked in their jurisdiction, may not work for you, right? But definitely it's something that I think you should seriously consider, especially given the amount of you know, wrongful convictions that have been uncovered in this nation.
Thank you. Anybody want to add to that?
So I agree, of course, with everything Cynthia said. I just want to address some of the, you know, there was one question about what do you do when your county doesn't have a CIU and they're refusing to open one. I think it goes back to what we've all talked about a little bit, is resources. So a lot of it is convincing the people who, you have to know who funds your prosecutor's office. And you need an elected that's going to embrace it, because it doesn't make any sense to have a conviction integrity unit if you have an elected prosecutor who's never going to be willing to agree, or it's going to be very difficult to get that person to agree. So I think a lot of it from an outside perspective is pressure, just figuring out how to work with constituency groups like the Innocence Project, if there is one in that county or in that area, or other groups that can push for this kind of unit. And sometimes with small counties, they can't have a unit. So I think, you know, resources plays in over and over and over, because if you have a small prosecutor's office, you might not be able to allocate a lot of resources to have an individualized unit. It doesn't mean you can't perform the function. But I would just add to what Cynthia said. I think the most important thing about the CIUs and going forward, and for people who are advocating for them where they don't exist, is this is about justice. I mean, if you work in a prosecutor's office, you don't have a duty to convict people. You have a duty to do justice. And we have just as much of an obligation to undo something that was done wrong as we do to move forward on a case that needs to be prosecuted. And so I will say there can be a lot of hostility in prosecutor's office when these units are created. And when you bring in someone, Cynthia's been there long enough. I don't know if there was any, your unit was so new. I don't even know if people knew what to push back against at that time. But for Risa, Shelly, and I'm sure, I don't want to speak for anybody, but I would assume they experienced something similar to what I experienced, which is you're a prominent defense attorney and now you're coming over to work for the prosecutor's office, an office that you've you know, butted heads with probably a lot over your career, and people are very distrustful, and then people view you as like an internal affairs unit. You know, are you coming to look over my shoulder and make sure I'm doing my job right, and who are you to do that? And you have to kind of work through all that to say, no, this is about justice. Mistakes get made. It's not about shaming or blaming. It's about acknowledging that we're human beings. We all make mistakes. I've yet to meet the perfect person. And we have to acknowledge that mistakes get made, corners get cut, things happen. It doesn't mean it's purposeful. It might be purposeful, but it probably isn't. And we have to be willing to take an honest look at the practices of the past. Like Barry said about the case with 6, you know, jailhouse informants. I can't imagine any jurisdiction in 2021 trying a case with 6 jailhouse informants. Maybe they do, but it's a practice that I think is now becoming much more well-known, how apt it was to be abused and contribute to wrongful convictions. There was a long answer. You asked for short answers, so I'm sorry. I'm gonna mute myself.
No, you were within the 2 to 3 minute request that I made before the call, so no problem at all. One thing I've been wondering, and I know we have a couple questions from the audience, is how your units collaborate or work with the attorneys who bring cases for you to review, whether they're privately retained defense attorneys or from the Innocence Project or Innocence Project affiliates. And so an example of that is, do you require a full waiver of attorney-client privilege before you review a case? And how do you collaborate with defense attorneys in what, as Valerie just said, is often a very adversarial system?
I can answer that. First of all, those of us on this panel who were defense attorneys for many years before we came to conviction integrity often have a relationship with a number of the defense attorneys who bring cases to us. So I think there's a certain level of trust between the district attorney's office and defense counsel in these collaborations that doesn't exist in a typical prosecution, where typically the district attorney's office is, you know, prosecuting your client and they want to put them in jail. Whereas in conviction integrity, what we're doing is we're looking for the truth. We do not, in the Bronx, we do not require that the defendants waive their attorney-client privilege. In our investigations, and I'm curious what other people have found, we're more looking to see whether there was a breakdown of the integrity of the process such that we just have no confidence in the conviction. There are several cases in which my district attorney, Honorable Darcel Clark, has decided to vacate convictions where we really aren't sure if the person is actually innocent, but there was such a breakdown of the process that we couldn't trust the result. So I think that it's really uncharted territory, the conviction integrity in a prosecutor's office working with defense counsel. But in my experience, it's been very productive.
So, go ahead, Barry.
Yeah, if I could just jump in terms of what processes should be done, I've actually written something that we'll put up, send out in the Ohio State Law Journal that's called Conviction Integrity Revisited. This is the second article I had written about this. There's really 3 altogether. But that article really is based on what we learned in those early days in the Dallas District Attorney's Office, as Cynthia described it, because the whole process emerged on how to do this, and it just wasn't reduced to writing. So I made my very best effort to do that. And one of the great principles is doing a joint reinvestigation. So the theory would be that an innocence organization or a defense lawyer, in bringing a case to a conviction integrity unit, ought to have some plausible claim of innocence, right? Otherwise, why bother doing this? Some evidence that you think is going to show that somebody's innocent. And then, and this is something that I think we have to, are attempting to train defense lawyers and certainly innocence organizations on how to do. I think the process works best and we've talked about how it should proceed, where you bring this evidence to the CIU and you say, okay, we're going to show you everything that is not attorney-client privileged information, but if we have an investigator that went out and spoke to some witness that we think is a basis for exculpatory evidence, we'll give you not just the sworn affidavit, we'll give you the underlying information, the work product, because you know, even people in a CIU, if I walk in the door and I have a whole bunch of affidavits, you're going to start thinking, did somebody tune up these witnesses? And if you're on the other side in the Innocence organization of the defense, you always get a little bit worried when somebody goes out and interviews a witness and that, you know, maybe the prosecutor will be able to get access to, the defense couldn't, but you want to have some way of documenting what they said, or preferably have your own investigator there when this goes on. But you should be able to bring this information all together. And what we prefer to do, you know, I mean, Risa knows this well from the Hugh Burton case, which is back in the news these days. You sit down and you say, okay, how are we going to do this? We haven't spoken to witness A, B, and C, right? Let's do that together, or maybe you can get to them. Let's plan it. And here are some, you know, forensic tests that maybe we have to do. And, you know, Innocence Project can say, we'll pay for them, but maybe you'll find a way to pay for them. And let's just see what the process brings and discuss what the next step should be. But the single most important thing, if you can do it, and I know that, Alyssa, in your last conversation with Brooklyn about the Mark Denny case, this was critical as always, and that is enter into an agreement. We used to do it informally in Dallas, and now it's very frequently it's done in writing, where you agree that you're not going to share any of the confidential information going back and forth between the CIU and the Innocence organization during the reinvestigation until you either decide the conviction should be vacated, either on due process or newly discovered evidence grounds. It should not be. Very frequently that happens. Get a test result and you realize this is not going anywhere, or we can agree to disagree and we'll go to a judge to solve the problem. But you don't do it then, you don't, you know, leak anything to the press. It's got to be really an agreement where, you know, people, there'll be maybe even some consequences or whatever, but that's the best way to proceed. But the most important thing is you should be able to get an Innocence organization or defense lawyer access to the prosecutor's file, all of it, including the work product. Because I can tell you, I've done more of these cases than anyone in the United States easily. And the bodies are always buried in what people believe is work product. That's where you see what's the problem. We've got to come to terms with being able to do that.
Valerie, I think you were going to mention something, and I wasn't sure if you also have a similar policy where you provide the entire file from the DA's office.
Oh, yeah, we do. And I was just going to say, it's a search for the truth. So unlike what Risa was talking about in terms of, you know, going to trial and this adversarial process, we're all searching for the truth. If the person's innocent, let's do something about it. If the person's not innocent, then the right person was convicted. I mean, either way, I always tell my team, I was just talking to my detective before this call, and she says, oh, we spent so much time on this case and you know, and they're all lying to us. All right, that happens sometimes. There's nothing we can do. We have, you know, you can't, there's no crystal ball when you start an investigation and say, oh, we're only going to investigate this case because, you know, we think he's innocent. You just don't. I mean, that's the whole key of what we do. I mean, when we look at the whole file, you can see the bias that crept into the police investigation. You can often see what went wrong, right? You can see the tunnel vision. You can see how one person became an easy target and the police built the case around that person. And all these other people over here that could have been investigated, they were never even looked at. And that's the benefit of looking back at something. But I also agree, I've always said, and I love working with defense attorneys, not just because I was one, but because I think the more minds that come to look at a case, the better your work product's going to be. I mean, that's, you know, the more people thinking about things and exploring things and brainstorming about, we brainstorm with cases with defense attorneys. We have no problem letting defense attorneys join our interviews if we don't think it's going to impact the integrity of the interview. I mean, some witnesses, you don't want to do that, but it's always a case by case, and I'll talk to the defense attorney. So as much as possible, we're very collaborative. You know, we're going to get the police file. I'm not going to make the defense attorney file a FOIA or go through some other process. We get it, we're going to turn it over. So I think that's really important in terms of the community trusting us. And by the community, I don't just mean like the defense community. I mean the community, our entire community trusting that this is a real process, that the prosecutor's office wants to get to the truth, that we're not afraid of the truth. And that when we find it, we're going to, if there's something to be rectified, we're going to take the steps to rectify it.
Do any of the prosecutors have a different approach, Shelly?
Alyssa, I was just going to say that, you know, my experience, and no, my approach is the same. I mean, I think that I'd like to think that the defense attorneys that have worked with me would come away from that saying that I had been very collaborative with them. But I was also going to say that surprisingly to me, about 99% of the petitions that I received or receive are pro se. So I very rarely have defense counsel bringing something to me. And as a defense attorney who practiced for 2 decades, you know, and there's the case that you couldn't put down or that, you know, you lost sleep over, I expected that there would be a floodgate of defense attorneys contacting my office and bringing cases to me. And really in the last 3 years, I've probably had half a dozen. And so for me, this has not become, you know, an issue that surfaces very often. And so most of the time I'm working with the pro se petitioner, and I am asking, right, for a waiver of attorney-client privilege if I'm going to go talk to their trial counsel or something, you know, along those lines. But I've not had the experience of defense counsel bringing me a lot of cases.
For us in Dallas, we're also like Shelly, the majority of our cases are pro se. However, if we're going to open an investigation into somebody's case and they're pro se, it is much better to just, you know, either approach the court if you really think that there was an issue here or there could be an issue, approach the court and ask for them to appoint an attorney, which our courts in Dallas are typically, you know, helpful in that sense. Or, you know, if they've written to an Innocence project before, then we ask them to get back in touch with them, and then we can start the process through counsel. It is so much easier to work a case when you have counsel on the other side. I mean, I think everybody would agree with that. In Dallas, I think we've established a trust relationship with the defense attorneys that we work with. It's a relatively small community of lawyers who practice innocence work and who bring cases to us. However, the defense bar in general have brought cases to us and they've never worked an innocence case. So they're relying on kind of us to help guide them in what they're doing. But you know, I think that establishing trust with the defense when you're working on cases is just imperative when you're trying to work an innocence case, because there are a bunch of things that to protect the integrity of your ongoing investigation, you either cannot reveal at this moment, you know, or you're going to have to hold on to it, or you can reveal only portions of it, and you have to trust that the other person will honor your, you know, their word that they're not going to go and publish it to the media or anything like that, or to go and do something that would sabotage, which seems contrary to what, you know, the goal is, but you'd be surprised. So I think, you know, we've also established a written kind of a cooperative agreement that we, you know, have done it in writing. In Dallas, we had for years only done kind of a verbal agreement with defense counsel. And in about 2015-ish is when we got a taste, I mean, we got burned on something. And so we said, no more, we're going to do it in writing. And it took us a while to hammer out what we were actually going to do, but we actually have something in writing. It's called a cooperative agreement. We do not require waiver of attorney-client privilege. And it's basically an agreement between the state, the defense, and the client. The defense's client has to sign it to acknowledge all the things that their attorney is agreeing to. And so we have found that it's working fine, but you know, it only takes that one time to learn your lesson, I guess.
Thank you. We've talked a bit about your relationship with the defense bar, or in Shelly's case, primarily pro se defendants. One relationship I also want to explore is your appeals unit, assuming you all have some form of an appellate unit in your office. And so can you talk a little bit about your relationship with the appellate attorneys at the DA's office? It would seem that the appeals unit is working some cross purposes with your units, especially in appeals where due process violations are alleged that could undermine the confidence in a verdict. And so do you somehow ensure that appeals are flagging cases for you? And then on a related note, do you require that an appeal is exhausted before you'll consider a case?
So maybe I'll start on this one because I've talked about this a lot. And in our office, Michigan has a unique system in that we have a unified appellate system. So you're required to investigate and exhaust all issues on the direct appeal. So what we've done in our office is we now have a procedure where in the appellate division, if someone is maintaining innocence and there's any new information, meaning information that was not presented, it's not an on the record issue, they have to bring in the CIU. They're required to refer it to the Conviction Integrity Unit. In terms of our post-conviction process in Michigan, which we also have a post-conviction process, it's called a motion for relief from judgment. Every single motion for relief from judgment that's filed comes to me. I review it. If there's anything even close to a factual innocence claim, I keep it in my unit for investigating the innocence claim. I notify the judge and the appellate division, and then we investigate it. And then if we don't agree to relief, it gets returned to the appellate division so that person can litigate their claim in the court. So from my perspective, I think it's really important if there is a CIU in the office that all things innocence, not at trial, you can't do trial, but all things innocence, post-conviction, I'm funnel through the Conviction Integrity Unit.
I think I should step in here because a lot of people that are in the chat now and in general who have done innocence work wind up in Conviction Integrity Units, right? So we do get calls from our friends who are doing this work. And the truth is that there is a tension between the CIU and the post-conviction. And I think in quite a number of offices, you have to make a choice. And I think that's a good idea because the CIU ought to be isolated, right? From, obviously the line attorneys, particularly the prosecutor that did the original case, if they're still in the office, that person is a witness, that person is not making a decision about what happens at the CIU. And in terms of post-conviction, there can be a lot of tension there because even when you're reviewing a case in a CIU, you will see things that happened in appeals or even in post-conviction litigation that have to be reinvestigated again. So it is best to separate those units. A number of people say you have to make an election. If you're still in post-conviction, you have to withdraw that to come and go through the CIU route. And I think, generally speaking, that's a good idea. But I'm so glad that all of you talked about this pro se issue. Shelly, one of the things that was really wacky about, this now, we started the Innocence Project 1992, what we found is that there weren't a lot of defense lawyers that were knocking on our doors screaming, you've got to look at this case. I know my client's innocent. we would wind up, having DNA tests that would exonerate people, and we call up the defense lawyer and they go, "You got to be kidding," right? When they should have realized that there was a problem in the case in the first place. So people, I'm not in no way surprised that they're not knocking down their door. And in fact, one of the things that we use is a pretty good indicator. If some defense lawyer is adamant that they have an innocent client, that's a case we'll look at more carefully than others. But I think that, and I know a number of people in the chat have mentioned this, the answer that Cynthia gave about having a court-appointed lawyer, right? If you have decided that this is a case that really deserves attention and a CIU is a good idea. And I know innocence organizations would also welcome an invitation to jump into the case to provide assistance and even resources. And one of the things that's happening now is, in San Francisco, and I think pretty soon in a statewide unit in Minnesota, what Shelly is doing, you're short of resources, so you'll go to law schools, to try to provide some assistance in doing the work. And I think that's actually a good development, right? Especially when you get into doing things like, I see, I'm looking at Adele Bernard's name in the chat, so I have to think about it. But, there are innocence organizations that you wind up in a situation where there's an audit, right? There's an exoneration, and you identify that there are some police officers that deserve additional attention because if they broke the rules in the case that leads to the exoneration, they may have broken rules in their old cases, and those deserve audits. And, there's a number of jurisdictions where there have been mass exonerations almost. Detective Watt in Detroit and Detective Guevara, there are audits going on, and that's something that really ought to be done. And CIUs, I think, have to figure out how to do those as well with outside assistance. I think in particular, that's a great thing to do. So, please, the pro se cases, reach out to innocence organizations, reach out to law schools, get lawyers appointed. There's a great tradition, they appointed lawyers, in Gideon, right? To represent the indigent. So you ought to do that when you have a concern, and that's a great way to do it.
Cynthia, Shelly, and Risa, do any of you have any comments about your relationship with the appeals bureaus in your offices, assuming they exist, in terms of how you interact with them on cases?
I mean, sure. We are one of those offices where you do have to choose if you're going to go forward with your appeal or you'd rather have a conviction integrity review. But New York is somewhat unique in that a post-conviction motion to vacate the conviction doesn't necessarily have a time bar if it's based on something like newly discovered evidence that could not have been discovered with, using due diligence. So you could 10 years later bring a motion and there's no automatic time bar. But in terms of, unlike Val, the motions to vacate the conviction are typically filed in court and served on the appeals bureau. The appeals assistants look at them, and if they have a case where, especially in the beginning when the CIU was new, where there was an actual innocence claim raised, they would provide us with the motions to take a look at to see if we wanted to jump in. Since there's been a lot of press and the CIU is known to exist, many people, not just lawyers, but even pro se defendants will approach the CIU before filing a motion. In terms of whether we agree to toll time, for example, we had a case once where there was a federal habeas pending. We agreed to, that could be told to look into some innocence issues. We're very accommodating in agreeing to waive procedural bars when we can do it, when it's legal. But we don't do a parallel investigation with the appeals bureau, and we are very separate. And there have been some cases where we've done a conviction integrity investigation, and we've not been able to uncover evidence that the person was actually innocent or there was wrongful conviction. And then we tell the person or even the attorney that they can move forward by filing a motion and the appeals bureau will respond. So that does happen.
So we have a written policy in our office that basically says if the appellate division, because they're the ones that receive service of any of these writ of habeas corpus applications, if any of those applications raise actual innocence or even anything that sounds like actual innocence, because, you know, sometimes it could be, you know, an allegation of Brady, but in that they're talking about I'm innocent, and if you would have, you know, provided this, it would have, you know, helped in my defense or whatever. So if there's any indication that the person is raising actual innocence or is even touching upon the subject, then the writ of habeas corpus application has to be sent to the CIU for review. So all this stuff is in a policy, and, you know, I'm trying to see how we can revise the policy. At the time, there was the DA who implemented the policy or who signed off on the policy wanted the appellate division to have the ability to work cases in conjunction with the CIU if, you know, if that person elected to. I find that to be a little bit odd. Nobody's taken us up on that, but it's odd because you could have that weird tension within your office. It's happened before, not in a situation like the one, you know, through the agreement, but there was another case where you know, the DA wanted the CIU to look at this case and the appellate division to look at the case. And we were questioning the same witnesses at the same time. And it sounded like we were from completely different offices. And so it just gives this kind of odd perception for the witness and can be confusing, and it's just not helpful. At the end of the day, there always will be, I think, tension, whether it's spoken or unspoken, between the units and the appellate divisions. There just is, for whatever reason. And you just have to somehow deal with it. It's just part of the job.
I don't have much to add other than what's already been said. You know, in Florida, there is a time issue for post-conviction motions. And so, you know, unlike New York, I can't tell somebody to withdraw their post-conviction motion, allow me to look at something, and then in the future they can refile. So we primarily require for post-conviction to run its course. Like Cynthia, if somebody brings an innocence claim, the attorney handling that is supposed to rope me in, and that has happened. And we have gone to the judges and asked for additional time for me to be able to look at something. Where we really began to see issues with this was on our post-conviction DNA motion request. So in Florida, there's a 3.853 motion that can be filed requesting post-conviction DNA. And typically what would happen is that we would oppose that. Then they would file a conviction integrity petition, ask for the DNA to be done. I would look at it and think, well, there is a nexus, let's go ahead and run DNA. But we had just gotten done opposing that motion, you know, in post-conviction. So at some point in time in the past 3 years, we then shifted our policy that when a 3.853 motion comes into our office, I'm then roped in on the front end on that so that we can then collaborate to determine whether or not there would be a nexus and a reason to agree to DNA testing. But other than that, I don't have much to add other than what's already been said. But these are tricky issues.
So Alyssa, can I just add, I think everything that we all said goes back to one basic concept. And I'll keep going back to it, which is justice. We should all be working together to achieve justice, and we should find the best method for our jurisdictions, and every jurisdiction has different hurdles. So there is no one approach that you can say can work in all 50 states. It's not going to happen because there's all these different restrictions on post-conviction motions and how they work and what judges are willing to do and DNA and all the rest of it. But I think the common thread for all of us, and for some of the questions that people posted, I guess this is more to some of the questions, is take a look at the overall office and what can you do to conserve resources and make sure you don't have the CIU at odds with your appellate division. Because again, it goes back to the community. Do you care about justice? Do you care about innocence, or don't you? Because if you do, your appellate division shouldn't be expending resources fighting something that the CIU is willing to investigate. So you just have to figure out the best course for your particular office and jurisdiction on how to achieve that and send a singular message to the community that innocence matters. We take it seriously. We're going to investigate it. And we're not going to make you, if you can, we're not going to make you fight an appellate division that has a much different mission. Even though every prosecutor's mission is to do justice, we all know in reality, an appellate division fights to uphold a conviction, and a CIU, operates extrajudicially. So I think, that's a common thread. And I think for the people in the chat who are asking all these questions, that's what you want to think about on a global level. What is the best way to do justice? Not waste resources, not send conflicting messages to your bench and to the community and to everybody that's dealing with you. And just how can you achieve that in your jurisdiction?
Thank you. Another question that we've been getting a lot in the chat is, what are your criteria for reviewing cases? So if I remember correctly, Valerie, you look at all cases, right? Whether it's a misdemeanor, felony, claim of innocence, if the person has pled guilty or not. And so I believe that's correct.
Yes, we probably have one of the broadest sets of criteria of anybody. And it also results right in our kind of being underwater all the time in terms of the petition, the request for assistance that we receive. And I saw one of the, I think, was it a chat question or one of your questions? The question you gave to me was, how do you deal with that? And so there have been some chat questions about triaging, and you just have to, you have to set a priority system. And I know Cynthia has, I think, a really good one. I have one that's decent, but almost never implemented because we have so many court deadlines. So because we're so expansive and we want to catch innocence at the moment we can catch it, I like Risa was saying, she stayed federal habeas petitions. I've stayed Sixth Circuit proceedings, federal district court proceedings, Court of Appeals proceedings, Michigan Supreme Court proceedings, trial court proceedings. And so when you have all these deadlines driving you, it makes it really hard to implement a good triage system. But theoretically, so I'll let Cynthia talk about that, because I mean, really, you should be looking at the people who have been in the longest, right? That's an easy way to say how we triage cases. But in reality, it just doesn't always happen that way because there's so many things going on. And you might have a case where someone's been in for 40 years and it could take you months and months and months and months just to find transcripts and the police file. So in the meantime, you're not going to not do other work. You're going to move on to other cases. And so you start this mixing bowl of cases in different postures, and then you get to whatever case you can get to because everybody's maintaining their innocence. So it's hard to say that, all right, we're 3/4 of the way through this investigation, but now I have transcripts over here on a case that's higher priority. Should I drop this investigation and go back to this investigation? Or, so you just got to make decisions that you think best reflect, getting through the work and in the most streamlined position. But certainly for us, I can say theoretically people who are out are the lowest priority, but we had a case with the Innocence Project in New York. And the gentleman had been paroled and he received relief probably last year. Part of the reason for that was, though, going back to what Shelly said, how many lawyers are pounding down your door? Not many. The Innocence Project was pounding down my door. Like the minute I set up shop, they were on me about the case. But that's great because they had everything packaged and ready. So I can't say no to that case when I don't have anything else and it is in a posture to go forward. Why wouldn't I take that case and look at it especially because it was a sex offense case. So he had collateral consequences to the conviction, and it was significant. And so it was, that's a really long answer that meanders a bit, but I think you get the point that, you know, we do the best we can to triage, but we have so many factors coming at us from so many different perspectives that it just doesn't always work out the way theoretically it should.
100%. I think, I'm sorry, Lisa.
I was just going to say, I think the point is Valerie's not sleeping.
Yeah. But she looks great. Look at her. But I think what works in theory, or should work in theory, never works in practice. So when you're setting up your unit and you're trying to come up with your policies and procedures and you know, I'll tell you, in Dallas, do we have the written policies and procedures about everything? No, because it's hard. It's hard to come up with something that you're going to always look to and say, you know, this is going to be, you can have guidance, right? But that's not going to always guide your practice, because everything's going to be in a different posture. You have all these balls in the air and you're trying to juggle everything, and it doesn't work out just like you have it in your plans. Okay. So it's flexibility is a big thing in CIU work, flexibility. So when you're writing your policies and procedures, don't write yourself into a corner, because what works in theory and what looks great on paper is probably not going to work in practice. So be flexible. You're going to be okay.
One thing I'd like to add, and we typically only look at serious violent felonies, but we make exceptions and we've looked at misdemeanors, is do not decide not to look at plea cases. People plead guilty, they are not guilty. We had two really heart-rending exonerations of people who had entered pleas of guilty because it just seemed the only way out to them. But there's no question in my mind that those two people were actually innocent. So do not disregard the guilty plea cases.
Yeah, and I would just piggyback that it is sort of like drinking out of a fire hose. And I think that all conviction integrity units are in the same boat when it comes to that, which is why, you know, I am partnering with the law schools to try to get more eyes and more hands on deck. Because if you're casting a wide net, like Valerie discussed, you know, you're looking at any case where there's a claim of actual innocence. My office just looks at actual innocence, and we typically do not look at misdemeanors, but, you know, we look at pleas, we look at certainly jury verdicts, and you're being inundated and it's coming in. And so you really, if you can work with, I had also tried to partner with one of the law firms in town, you know, who was willing to expend pro bono hours looking at our petitions. And so if you can get creative and get more eyes on petitions and more hands on deck, you know, you'll do better for yourself and your unit, but you'll be underwater no matter what. I mean, I'm assuming that Cynthia, after a decade of doing this, still feels like she's underwater. And so I don't know if you just try it, you're treading water.
I could just really make you all nuts. You know, this is the work you're doing is so important, and I must say inspirational to people like me, because I'm sure you're seeing that, you know, we're changing these institutions in a very profound way at an inflection point in the way America is dealing with criminal justice and problems of race, let's be honest. And one of the things that recently a number of us recommend and, you know, believe is a best practice is that conviction integrity units ought to also be looking at excessive sentences. Because when you really start looking at the pleas, and it's so good that, you know, everybody here is acknowledging that innocent people do plead guilty. And we can prove that in pretty profound ways. You know, in Harris County, we had all these people that were pleading guilty in narcotics cases when they didn't have narcotics, you know, and there was a whole rash of exonerations around that, but it's demonstrable. But, you know, we have issues that have to be paid attention to. I wish that progressive prosecutors would work with their conviction integrity units and others to start looking at the issue of what we call the trial penalty, right? If you haven't looked at it, you should take a look at the NACDL publication about the trial penalty that deals primarily with the federal system. There's something coming out, I know, in New York State around this from the NYSACDL. But look, it is rational with mandatory minimum sentences for people to plead guilty who didn't do it, rather than go to jail for extensive periods of time. Anybody that's been a defense lawyer has seen that happen, right? You don't want to talk about it or admit it, but it does happen, especially with these mandatory minimums. And when we're really serious about issues of mass incarceration, it is time to think about being able to look at excessive sentences. And people are beginning to do that. In the chat, somebody said, how can you begin to look at this in terms of data? Our friend Rachel Barkow at NYU, and I saw Courtney in the chat, has written some really solid stuff about how you can look at people who really have aged out on crime, who should be getting some kind of relief from sentences that would never be given out now, but are things that happened in the past. So there's so much that conviction integrity units can do, including some of the things in the chat, going back and doing what we call sentinel event reviews, trying to figure out, I'm not saying that you all have the capacity to do that right now. You would have to need the help of others to try, going back and looking at some of the old cases and trying to figure out, what went wrong and how we can fix it, doing some kind of root cause analysis. So I just think that the work you're doing is the most interesting and creative space in the criminal justice system, or one of them certainly. And let's get Senator Klobuchar to give you all some money. That would be a good idea, right? Shouldn't just be in DNA, should be in everything.
Related to that note, Barry, we had a panel several months ago about sentence review and how different prosecutors' offices are trying to make that a reality. And so I'll ask one of our staff members to put a link to that in the chat so people can watch it later at their convenience. So much of the conversation has been about resources. We are also seeing several questions in the chat from people in very, very small jurisdictions. So unlike the panels here, not jurisdictions of hundreds of thousands, but probably 5,000, 10,000, 50,000. And so for those offices that only have, say, 5 prosecutors total, do you have any advice on how they can, if not start a unit, at least try to take a look at some of these cases? I know, Shelly, you mentioned, using, I think it was Shelly mentioned using law school students, but any other ideas? Even we've had some questions about funding sources. So any advice you can give to those offices that really want to do this important work, but just don't have nearly as many prosecutors on staff as some of these offices?
One thing that should be mentioned is that there are now efforts to do this statewide, right? So there is, New Jersey has formed a statewide conviction review unit that they're getting off the ground. And New Jersey is a bit peculiar because the Attorney General has plenipotentiary powers and literally supervises all the district attorneys in the different counties. But that's one place. And they're doing the same thing now in Minnesota, where Keith Ellison is forming a unit there. And they have some of the line prosecutors on their advisory board that have made commitments to give up their files and allow the CRU to do reinvestigations. And there may even be law schools there, I don't know. So I think there's a lot of creativity that are forming now as I think, people being elected to offices, are what we call progressive. There doesn't mean they aren't interested in, apprehending the guilty and doing a good job with that, but really trying to look at the system as a whole. So I think there is some future in these statewide type units that can provide assistance to smaller jurisdictions.
So I say Michigan, oh, I'm sorry, Cynthia, you go.
No, I was just going to say, if you don't have money for a standalone unit, you don't have the budget, you can have, you can open up your files to the defense attorneys when they come on board, you know, with the case and come and present it to you. Of course, you know, you should execute a written agreement before you do that, just like we do in CIUs. But, you know, you should, you know, you could open up your files. You can go gather your, not only the district attorney files, but the police department's files, and the medical examiner's files, the lab's files, all those files. You can gather all that, make sure you have everything, make sure you always had everything. And if you didn't, maybe you'll find something that you didn't have that could have made a difference in the case. Don't just assume that because it's not in your file, it never existed. We've learned our lesson in Dallas, and we know that that has happened around the country. So you can still do those things. Now, if you don't have like an investigator with your office that will help you go out and investigate cases, maybe you can establish a relationship with your police department. Do they have a cold case unit? Do they have a detective that maybe you can establish a relationship with in terms of them helping you out in investigating these cases? It's about, a lot of this is about mindset, and we'll just kind of park that there, because mindset goes a long, long way. If you have the support of your elected, the mindset of everybody else in the office should follow. And if you really want to do this kind of work and you don't have the budget, doesn't mean you can't do it. You can. It's just a matter of implementing that mindset and different things that you might not ordinarily do. Don't, you know, resist the urge to put in your procedural bar, you know, hold on a minute, relax, take a step back, look at everything. And if you really want to do this kind of work, you can do it.
There are also BJA grants available that maybe people are not aware of. My office received a BJA grant. I know Fort Lauderdale has received one, and you know, our office as part of our BJA grants. And so there is money out there if you're, you know, willing to look for it and, you know, write a grant and ask for it.
And I would just echo what Cynthia said in terms of mindset. If you want to get it done, you'll get it done. And access to documents, I can tell you as a defense attorney, I never knew what I didn't know until I came to the prosecutor's office. The access to documents is just so stunted for a defense attorney, whereas a prosecutor can pick up the phone and get the police file, get the medical examiner files, get all the evidence tech notes. I mean, anything that's associated with the case. And I don't know if this follows what other people have found, but almost every innocence case that we've had in this unit, and you said that we had 26, so I just want to add, we have 28 now. We've had one last week and one the week before. But we have found poor police work. I mean, at best, up to purposeful bad police work, but poor police work with the tunnel vision, the bias and everything else. And so once we get those files, it opens up a whole new world, because to do a good innocence, anyone who knows how to do an innocence investigation knows you have to start from the very beginning. You have to redo everything yourself. You have to look at everything with a fresh eye. So I just want to really echo what Cynthia said, getting those documents for the defense, not making them run around for a year or 2 years or 3 years and fight whatever people call it. We call it Freedom of Information Act in Michigan, but everyone has their own, you know, Florida sunshine laws, whatever the laws are, that can make it very expensive and time consuming to collect documents. You can help a lot. And then the other thing you should think about is, like, Michigan has a statewide CIU in our Attorney General's office. I was conflicted out of a case with 2 co-defendants because I had represented one of them and I had testified as an expert at their joint motion for new trial hearing. So I figured, you know, I can't really act on that in the CIU given my involvement in that case. So we signed a memorandum of understanding, and they took that case from our office, and they're going to handle everything. And then their CIU director was conflicted out of a case, and so we took that case. and I'm going to handle everything, but I'll still report to the Attorney General because it's an Attorney General case. The Attorney General on my conflicted out case will still report to my elected because it comes out of our office, but our respective CIUs are disqualified. So I think, again, going back to what Cynthia said, be creative. If there's a larger jurisdiction that has a CIU, see if they'll enter in a memorandum of understanding and if they'd be willing to take the case or work with you on the case. I've offered, when people have called me, to say, you know, I will work with you. I will walk you through how to do the investigation and how to go through this and how it should look. So I think there's lots of opportunities to be creative and do this. If your goal is justice and you want to do the right thing, you can find a way to do it.
Yeah, I would really emphasize what Valerie just said, because the more we do this work and you find cases that go back a long way and you have, you don't know this going into it, but you suddenly find out, oh my God, this particular cop or set of officers at a precinct or something, they've been involved for a very long time, and all these kind of conflicts can arise. You know, a good Attorney General's office, you know, in most states has the jurisdiction to deal with something like that. I mean, that's always been the safety valve. I know that there are provisions of it in New York law. The governor has to cooperate, but there are others. And that's the way to do it, because, you know, you will get into situations where, you know, there's an exoneration and, but all of a sudden it implicates, what about all the other cases? And then, you know, the integrity of your office is put on the line, and you want to get some support, because very often, you know, you can't do this all alone. People are going to always look at you and say, well, you know, you may have conflicts. You're covering up something. And that's the antithesis of what this kind of work should be. And, you know, we have to be creative in terms of, I think what Valerie wound up doing there is made complete sense and is a creative solution that people should think about.
All right, last question I think is going to be for Risa, and that is that we have a lot of line prosecutors, so not those who are heads of conviction review units or necessarily elected DAs, but line prosecutors watching this panel. And is there anything you can tell them about how they can ensure that their cases aren't later revealed to be wrongful convictions? It's every prosecutor's nightmare. And so what are some common red flags for them to look out as they investigate their cases?
Thank you, Alyssa, for asking this question. And I just did train on this for the new assistant district attorneys at the Bronx County DA's office. I know we're really out of time, so I'll try to be quick. But what I will say is that what you have to keep in mind is defendants will falsely confess. Some identification procedures are more reliable than others, and it's counterintuitive. Things that we used to think were really reliable. Oh, the victim looked at 1,000 photos and then picked out this person. That must be the right person. Actually, if you look at the science behind it, that's the least reliable. Single witness identification cases are extremely problematic. And, but the most important thing that you can do, just keeping all these, you know, factors in mind of what can lead to a wrongful conviction, while you're prosecuting these cases, always be mindful of turning over every piece of information that could be considered Brady. If you have a question, whether it's Brady, it probably is. Secondly, you need to keep in mind the whole concept of confirmation bias and tunnel vision, which is that you're seeking or the interpreting of evidence in ways that are partial to your existing beliefs, expectations, or the hypothesis at hand. And this came into play in a case I was actually involved in years ago when I was a defense attorney, that the defendants who were convicted at trial were exonerated by the Bronx County District Attorney's Office before my elected was even elected, before there was a conviction integrity unit, but by actually the Appeals Bureau agreeing to join the motion of the defense attorneys. And in this case, what happened was 2 young prostitutes spent the weekend, the entire weekend, they slept at his house with the victim. They saw all kinds of expensive things there. They went back to their apartment and they told their boyfriends who were in the Bloods gang, this guy has a lot of stuff. They came back the next day claiming they had forgotten things. The guy opens the door and the 4 guys rush in with guns. They pistol whip the guy. They shoot him twice in the stomach. They duct taped him. They throw him in the closet and leave him for dead. But he wasn't dead. He crawled out. He managed to scream and somebody called 911. He was in a coma. And the police investigation ensued. What happened? Well, it turns out that during the weekend that the 2 young women spent with this guy, they had used his phone. So through phone calls, they tracked down a bunch of people they believed to be involved. 2 young women got arrested, Letitia Johnson and Melisha Blyden. They were investigated. Letitia was interrogated for hours and she ended up giving this whole crazy confession, naming about 4 guys who were involved, 2 of whom, at least one of whom couldn't have been involved because he was at Rikers Island, our jail, on the date of the actual crime. And if you look at that confession, you're like, okay, this can't be accurate. One of the guys she doesn't even know the names of, she's calling him question mark. But you're thinking, well, maybe she's trying to cover up for the real people and she's giving them these fake names and that's what's going on and she's actually really guilty. Ultimately, one of the people she names as being her co-defendants, her co-perpetrators, ends up getting arrested. He's questioned by the prosecutor's office and he says, oh yeah, my ex-girlfriend called me up. She told me she had to lay low for a while. I believe, and she talked about a situation just like that. Her name is Latrice. Now, the actual perpetrators had these street names of Lacey and Jackie, and the prosecutor said to him, well, you're saying her name is Latrice, but the person arrested, her name was Letitia. Her real name's Letitia, right? That's her legal name. He's like, no, her name is Latrice. And there's this whole back and forth. That's a red flag that wasn't followed. Then the case proceeds to trial. People's witness comes to the courtroom, looks at the 2 defendants at defense table and says, those are not the girls. This was somebody that lived in the apartment with them, was also a dancer, a prostitute, goes up to the prosecutor and says, those aren't the girls. Those aren't the girls that did it. Prosecutor does the right thing. He brings that witness to the defense attorneys. They put him on, but again, the jury's not convinced. Every other prosecution witness that testifies and identifies these girls says they look different since they've been in jail. One witness flips them. She says one is Jackie and the other is Lacey, and then turns them around. Ultimately, the Office of the Appellate Defender, my old office, investigated the case, found the real perpetrator, brought it to the Bronx District Attorney's Office, and these girls were exonerated. The real Jackie and Lacey were ultimately apprehended. They couldn't be prosecuted because the statute of limitations had run. But if you look at that case, it's just red flag after red flag after red flag that really, when something starts getting weird, don't ask yourself a question. Is this the right road we're going down? Stop and take a look back. Thank you.
Thank you. And I think Michelle put some links to those case summaries in case anyone wants to read more about them. Actually, technically, Risa, I think I promised the panelists 1:30. So if there's any last minute closing remarks from anybody, I'm glad we didn't have to cut off anybody, but any last words from anybody at all?
Oh, go ahead. There's a lot of questions. Do you want to throw one more question at us, or you just?
Yeah, I can. I just want to give everybody a moment.
Go ahead. Shelly wants to say something, so go.
I was just going to say, because there are so many questions that we didn't get to, just to let everybody know who's interested in creating a conviction integrity unit. There are now, agencies where you can go and get a lot of information and resources. So APA is collecting documents and resources that they're willing to share. The Cotrone Center at the University of Pennsylvania, put out a white paper of 2016, maybe, talking about best practices. They're also in the process of collecting documents from conviction integrity units around the country and resources. So I would contact, those two entities. PCE just wrote a white paper about creating a conviction integrity unit in October of 2020. So that would be a great resource for people. So I know that there are a lot of questions that we didn't get a chance to get to, and it's all so complicated and also individualized from state to state, how best to go about setting up your conviction integrity unit. But there, when I started in January of 2018, I was calling everybody in the country. And at that time, there were 33 units. Cynthia, I called you, I called Patricia Cummings, Mark Hale. But now we're starting to get places where you can go and get, a lot of resource. And so you don't have to make these frantic phone calls to people around the country. And so I just wanted to let everybody know about that. If in fact, we didn't get to one of your questions today.
Yeah, and Fair and Just Prosecution, the organization that Miriam Krinsky is the executive director of, they have principles as well. And I think that if people want it, there are quite a number of documents from transition teams that are public, having to do with new charters for conviction integrity units that I think I know people are willing to share. So you should reach out, and as Shelly said, there's a lot out there.
Yes, Shelly, you did my job for me. I was going to send everyone to PCE and the Cotrone Center. And there's so many resources. You can always email us at the IIP and we'll try to connect you with the right folks. So I want to thank our audience members. I want to thank all our panelists again. I know it's impossible to cover this really complicated and rich field in an hour and a half. But hopefully our audience members learned at least one thing. So thank you again, everybody, and enjoy the rest of your week. Bye-bye.
Bye-bye. Thanks.
Thank you.
Thank you.